government cannot take my Nerf guns.
Police, open up.
I know my rights. You can't come in without a warrant.
Okay, now on to the Second Amendment. And the Second Amendment, the court has really shied away from defining exactly what violates gun rights and what doesn't violate gun rights. They've left it up to the states to be able to impose restrictions on purchasing, on background checks, open carry, things like that. The two most significant cases to know, though, are Heller versus the District of Columbia and then McDonald versus Chicago. And in these cases, in the District of Columbia Heller case, essentially the District of Columbia said you could have handguns, but not outside your home, and within your home they had to be locked and unloaded. So very specific rules. And the court argued that at the heart of the Second Amendment is a person's right to self-defense, that is a right guaranteed to them. And so with the stipulations it put on having handguns locked and unloaded, it would really prevent someone from being able to defend themselves. So they ruled that that particular law in Washington, D.C. was unconstitutional. This, however, did not apply yet to the states. So the federal Second Amendment did not apply to the states until McDonald versus Chicago. This is the first time that this particular amendment was incorporated to apply to the states. And it had to do with a similar handgun ban in Chicago. And arguing along the same argument that they did in Heller, they basically said that it's a fundamental right and it's necessary that individuals have this right of self-defense. So McDonald versus Chicago is the case that applied this then to the states. It doesn't mean that states can't put restrictions on things like concealed carry or open carry or banning even certain types of weapons, how easy it is to get a weapon. So they've let the states pretty much go with making different gun regulation laws. But they've basically reasserted the right also that people have the right of self-defense. All right, now we're getting into the rights of the accused, which is what the 4th through 8th Amendments deal with. And these are to protect people who may be accused of a crime and to ensure their procedural due process. And by procedural due process, we mean that laws need to be followed in a certain way, and there are limitations to what the government can do, and they must follow certain procedures. So beginning with the 4th Amendment, this is often considered a right to privacy, but also your right to not be subjected to unreasonable searches and seizures. That basically means that the government does not have the right to just walk into your home. They must get a warrant. And in order to have a warrant, it must specifically describe where you're going to look for something and what you're looking for. So again, if they have a warrant to look for a stolen alligator in my house, they are not going to be able to come into my house and look in my kitchen cabinets or in a small jewelry box and try to find the alligator, because that's not a place where the alligator would be. If they were to look inside a jewelry box and find something illegal, maybe a piece of stolen jewelry, say, I would be protected under the exclusionary rule. So when they come into a home, there's really no incentive for police to necessarily follow the policies. And so that, even though the exclusionary rule is not in the words of the Fourth Amendment, over time the courts have found that it is essential to the Fourth Amendment actually being preserved within the Constitution. And the exclusionary rule states that the court cannot use evidence that is obtained unconstitutionally. It must be excluded from the trial. So I could still be put on trial for the stolen jewelry, but the fact that they found stolen jewelry in my jewelry box would not be able to be used as evidence. Now, this does not apply if the stolen jewelry was just sitting on my kitchen table and they happened to see it. That would be in plain sight. And in plain sight, they would still be able to use that as evidence, or if they would have found it. So perhaps I had the stolen jewelry in a big box or something where they thought the alligator might be, then that would be okay. And it also does not necessarily apply when officers acted in good faith. Like there was a mistake made, but it wasn't their mistake. They were actually doing what they thought they were supposed to be doing. Again, the key court case to know here is Matt versus Ohio. Matt versus Ohio is what incorporated the exclusionary rule to the states, okay, under that due process part of the 14th Amendment. Now I'm going to move ahead. Probably the most recent issue that you need to know and understand with regards to Fourth Amendment is the U.S. Patriot Act. And again, the U.S. Patriot Act did some things that would typically violate the Fourth Amendment. But because the government had a compelling interest, they had the right to do those things. So because it was trying to protect us from terrorism. Right. The USA Freedom Act then modified parts of the Patriot Act and put limits on the bulk collection of data. All right, moving on to the Fifth Amendment. Probably one of the most important parts of the Fifth Amendment to know is that you cannot be forced to self-incriminate. So you can plead the Fifth. You don't have to testify against yourself. And you have the right to remain silent. Also, you cannot be tried again if you are found innocent of a crime. So you can be tried by two different states for the same crime if you committed them across state lines, or if it's a crime that breaks both federal and state crime, then you can be tried in state court and federal court. And also it helps determine that a grand jury has to decide whether or not there's enough evidence for someone to stand trial for a crime that is made. So again, self-incrimination is probably one of the most important parts of it, that you cannot be tried again if found innocent of a crime. And then the grand jury indictment are all important. You want to make sure that you know your Miranda rights. And this came out of the court case Miranda versus Arizona, which is not a required case. But this is what ruled that actually you should be informed of what your rights are. You have the right to remain silent. Anything you say can be used against you. You have the right to attorneys present during questioning. If you cannot afford an attorney, one will be provided for you, which actually leads us into the Sixth Amendment. So the Sixth Amendment is the rights that ensure a fair trial. So that means a speedy trial. You can't be waiting years to go on trial. A jury trial. So a trial where you're going before your peers. They will decide your innocence or guilt. And then the one that relates to our key court case we have to know, which is the right to counsel. And Gideon versus Wainwright is the Supreme Court case that incorporated this part of the Sixth Amendment onto the states. And even though it was a law at the federal level that everybody had right to counsel, it was not necessarily applied at all state level governments. So this is what incorporated and said, no, states also must provide counsel. And that was important that be provided to individuals. So again, that's Gideon versus Wainwright. Sorry. All right, now we're going to continue with the Sixth Amendment of the Constitution. So I'm in the Interactive Constitution Center. And the Sixth Amendment is what really ensures a lot of due process to people who are accused. So they have the right to call witnesses. They have the right to a speedy trial and a trial by jury. And then the important piece here that is highlighted in the must-know court case is that they have the right to have assistance of counsel. So basically, they have a right to an attorney. And if you cannot afford an attorney, one should be provided to you. So the court case that said that this applies to all states, so it was incorporated this aspect of the Sixth Amendment to the states, is Gideon versus Wainwright. And you may recall Gideon was accused of a small theft, and he basically said he was too poor for counsel, and argued that he should have the right to an attorney provided to him. So a public defender. And the court basically reasoned that the American system of government is that every defendant should have an equal chance at a fair trial, and that without an attorney, a defendant does not have that equal chance. So that is what applied the whole concept of right to an attorney to every state, not just federal cases. So that's the most important part to know about the Sixth Amendment. Now, the other key amendment that we finished with was the Eighth Amendment. And the Eighth Amendment the purpose of the Eighth Amendment is to protect the accused from unreasonable penalties, fines, and punishments. The punishment should fit the crime. So probably the biggest issue that comes up here is the idea of, is the death penalty cruel and unusual punishment? Many countries around the world have banned the death penalty. It is banned in certain states in our country. And for a brief period in the early 1970s, the death penalty was banned. There was like a moratorium put on the death penalty, and that was the decision Furman versus Georgia. And basically the court said that the death penalty was not being applied equally across the board. It was kind of a random application of the death penalty. African Americans were being put to death at higher rates than white Americans. And once states started putting in place stricter sentencing guidelines so that there was a little bit more uniformity, in Gregg versus Georgia in 1976, the courts went ahead and said that, okay, you can have the death penalty back. However, over time, there are states who have found that innocent people were being put to death, and DNA evidence has definitely played a role in revealing some of those innocent people who've been accused on death row. So there are some states who have put their own moratoriums on the death penalty. However, the courts have ruled that mentally handicapped defendants cannot be put to death, as well as people under the age of 18 at the time that the crime occurred. So those are some limits that are on the death penalty at this point in time in our country.